that's the court's ruling, that's fine.
Please don't put words
I'm
in,
not sure,
in
Your
my
Honor.
mouth. I mean, no, that's really important, Mr. Rasmussen. Don't put words in my mouth because I never said that.
Mr. Belsky's case, and we'll get to those. If we go to line 32, or sorry, page 32, John, lines 12 through 18. And when asked her opinion, she had given on her differential 3 possible causes, and she believes that kratom is the cause of Mr. Belsky's liver injury. And so,
did she say what the toxicity levels would be as far as dosage is concerned?
well,
To cause liver injury?
so she testified, and the literature supports that this is another one where it's based on the susceptibility of the individual person.
But I mean, what's the toxicity level? Are you saying that there's something peculiar about them that if they take kratom, that they're part of that small class of individuals that has susceptibility to kratom?
That would be true, Your Honor, that's what she said, and that's what the literature supports.
But I mean, doesn't there have to be some level?
Well, that should be true for hydrazine too, but we don't have that level.
But no, I'm asking about kratom because I've never seen this before, and especially dealing with toxicity. And so my question is this: is there some level of kratom that's considered toxic?
No, because it's not a direct toxin. It affects everybody differently.
All right. Do we even know what the levels are for the kratom?
For who?
For the kratom, Mr. Belsky.
He testified that he was using it about 2 to 3 times per week.
Okay. How do we determine whether or not someone is susceptible to or sensitive to kratom?
Well, so there is a connection in kratom, just as there was to in turmeric, to a particular single polynucleotide. But again, not everybody who is determined to have had liver injury caused by kratom has that gene.
And my next question would be, from a genetic marker perspective, was there any testing in that regard?
I did not see it in the medical records that any testing was done, no.
But go ahead, ma'am.
Okay. So to support her opinion, Dr. Dara's discussed a number of peer-reviewed articles. So the first, and this is out of the drug injury, the liver network. John, if you could pull up the 2021 article in drug dependence. And again, this paper was peer-reviewed. If you go to, should be the next page. Yeah, under methods. Again, just like with turmeric, they use a standardized protocol. They use specific markers to show here's somebody that should be included or shouldn't be included as a likely or probable cause. And they actually here did gene sequencing on blood DNA to rule in or out suspected cases. And so it was a scientific study that was peer-reviewed, and they reported in this article that on page 5, to answer your question, there's a discussion of the genetic susceptibility. And so in the second to last paragraph, this I think answers your question, Your Honor. So they showed that there were 2 particular alleles that were more prevalent in those that were affected by kratom than the general population, and that And so they posited that that was possibly a linkage. But then in terms of the number of cases, again, in the next paragraph, they noted that the incidence of this was increasing because kratom use is increasing in the country. So that's why we see more cases now, and I'll show you the number of case reports has risen as well. So there's plenty of other peer review articles. John, we can just look through them. The 2015 hepatology case report. So kratom-induced acute liver injury, a case study, and the importance of herbal supplement regulation. This is something that Dr. Dara talked about in her deposition, because the question was put to her why you don't have clinical trials. And it's because there's, like I said before the break, there's no requirement that supplements do that. And so much of this literature that you'll see is calling for greater regulation of the supplement market precisely because of problems like this. John, the 2019 gastroenterology research. This is also a peer-reviewed study, and what they did was they did biopsies and determined that there were biopsy-proven liver injuries and connected it to kratom use. And on page 3, if we can go there, they have a summary of the prior literature showing that there's plenty of prior cases. So the table 2 up there.
Can you? Yeah, thank you.
So they summarize, here are some of the prior case reports that support our conclusion that there is a connection between kratom use and liver injury. And they go through them and talk about why they're similar to their case. So that's another study. Then the 2019 Journal of Investigative Medicine. These are authors out of Stanford University. And if we look at the abstract and towards the end, right, so the second to last sentence, kratom is associated with significant liver enzymes derangement leading to DILI, drug-induced liver injury. And so that was the conclusion of these Stanford researchers. And I believe in the conclusion of the paper, after they go through their findings, they say the same thing. Use of kratom is associated with acute intrahepatic cholestasis liver injury that can predispose to risk of progressive hepatic decompensation and liver failure. So then the 2020 International Journal of Medicine. On page 2, there's an abstract, also a peer-reviewed study. And this is another one where it's advising clinicians. That's what the point of most of these case reports are. They're advising clinicians when you're taking a history, you can't forget about herbal supplements. And kratom is one that you should look at when you've got an individual who has acute liver injury. So they talk about side effects from the compound have not been well documented, which is true, but they advise clinicians to be vigilant about the kratom hepatotoxic potential on patient health. So then the American College of Gastroenterology in 2021 produced 2 case reports. There's number 1. This is by doctors out of the Cleveland Clinic. And here they report a multi-organ dysfunction, one of which was liver, related to kratom ingestion. I believe they summarized that in the abstract as well. And they're talking about kratom has gained popularity. And so later on they say that that's why we're seeing more and more cases, which is why there was the 2015 report 2019, and now in 2020 and 2021, there's more and more reports coming out because it's gaining popularity. And then there's the other American College of Gastroenterology case report from 2021 out of the University of Missouri talks about another case of kratom-induced hepatitis, and it describes that case. Then we go on to the 2021 World Journal of Hepatology. If you go down to the start of the article, John, I think it's, keep going. Yeah, so, oh, okay, I see. I didn't tell John which one to do, but that's fine. So this was a peer-reviewed paper out of Georgetown. It did a full analysis of cases in the literature supporting drug-induced liver injuries caused by various herbal supplements. And down on, starting at the bottom of page 11 of the PDF, John. Updates on known hepatotoxins. And they discuss kratom, and what they discuss is that there's been an increasing use of it, and there's more reports of it being hepatotoxic, and cite many of the case reports that we've already looked at, Your Honor. And then there was one more World Journal.
What does that say at the very end? It talks about the next. It says, at present, there are known.
Yeah,
no,
so we can go to the next page.
I just want to see it.
There are no medical indications.
Okay.
And the FDA has labeled it a drug of concern.
The court will note that it's banned altogether in 6 states.
And we'll show that. That's actually a paper out of UNLV right here.
For opioid reasons, Your Honor, nothing to do with liver failure.
So then there's the other World Journal article from 2021, World Journal of Hepatology. If we go to page 2 under, there's a core tip. We can highlight that. Kratom-induced liver injury is an important differential diagnosis for physicians to consider in any patient presenting with acute liver injury. And here's the idiosyncratic part, Your Honor. As observed in our patient, this manifestation of kratom consumption may occur even at low doses. These were researchers out of Northwestern University, and this was also a peer-reviewed paper. So then, as Mr. Neale mentioned, just this year, 2023, the Journal of Hepatology published a paper out of authors from UNLV right here.
Okay.
And again, it's another case study reporting a case here in Nevada and pushing again for more herbal supplement regulation. If we go to, on page 1, there's a summary about the recognition of risks. That alternative medicine, and kratom is one of them, become the second most common cause of drug-induced liver injury. That's after acetaminophen. And then kratom is becoming increasingly available. But then we have reports of adverse effects with the kratom use increasing as well. And it's been implicated in acute liver injury, acute liver failure, organ dysfunction, toxicity, coma, seizures, and death. And again, what the UNLV researchers were trying to do is increase awareness among practitioners and promote increased regulation. So, and then on page 2, as Mr. Neale referred to, they were noting that there's an increase in regulation and it being banned around the country. And so the yellow states are where there's some regulation on it, and it's banned in the red states. And Dr. Dara talked about that in her deposition as well. So finally, just like turmeric, kratom's also listed on the NIH's liver tox registry, last updated in 2020. You just look at the again, the NIH says kratom has been linked to rare instances of clinically apparent acute liver injury. So that's some of the literature, Your Honor. And then for Mr. Belsky, this was also recognized by his clinicians. I think hopefully we have the May 26, 2018 record for Mr. Belsky. And go down. This is the day after his admission to the hospital. Go down again. It's towards the end. Keep going. Again. Yeah, okay, so he's under the diagnosis, number 1, talking about transaminitis, and it's likely secondary to meds and kratom substance use versus ischemic. That's what they're trying to figure out. So his doctors, his treating physicians have recognized that kratom is something that can cause impaired liver function. And then there was one other record, I believe. Do we have that one? Right, so this is a couple days later. And go down. And they specifically discuss that the patient does admit to occasional use of an energy supplement, which he reports he buys at a smoke shop called Kratom. And so then his doctors advise him to stop Kratom, which I think is a little further. Oh. Right. You keep going down the page. Next page, John. Talks there, he was using it 2 to 3 days. Keep going. I think we're looking for the, sorry, John, I probably misspoke. I think it's the May 28th record. Do we have that one? No? Okay. So then, in addition to Mr. Belsky's treating physicians and all this medical literature, if the plaintiff's expert, Dr. Freeman, also recognizes this risk. If we can pull up Dr. Freeman's report and go to page 34. Dr. Freeman, he notes that Mr. Belsky was using kratom every 2 to 3 days. He also notes that a literature review studied 404 cases of drug-induced liver injury and found 8, which was 2%, be associated with kratom. He acknowledges, as Dr. Dara will, that regular users usually don't get liver injury, but that some do, and that's the point of the idiosyncratic reaction. And then on the next page, that it is my opinion. He states that there's evidence to indicate that Mr. Belsky's hepatitis was likely due to a combination of factors, one of which was his repeated consumption of real water. So he recognizes that there may have been other causes as well, and has recognized kratom as a possible cause. And so it's our position that Dr. Dara's opinions, she's eminently qualified. Her opinions are well supported by the medical literature, more than satisfies Hall and Williams. And I'm happy to answer any questions Your Honor has.
Okay, and I do have some,
Sure.
I guess going back to we can break them down. We have, was it Mr., who did the, not the kratom, the, okay, Haley.
Yeah.
And what was the dosage?
He was taking up to 7 grams daily of supplements, which is a little different than pure turmeric, but that's what his physician calculated, that he was taking 15 times the daily recommended dose.
Do we know the dosage of turmeric? And this is Haley, right?
Yes.
I'll make sure I get them right. Do we know the dosage of turmeric? He was taking what again?
7 grams daily
Okay.
was what his, of various sorts, is what his physician calculated.
Okay. All right, and as far as Belsky is the other one.
He was using it based on his statements to his doctors. He was using it every 2 to 3 days. They did not get information from him as to exactly how much at a time. I mean, it's something that you brew into tea, so I'm not sure that's something that's...
So does the literature, whatever's out there, does it talk about levels of dosage?
It doesn't. Oh, I'm sorry, Your Honor.
Yeah, I mean, there's levels of dosage that would be required to cause some sort of adverse health outcome.
It doesn't. It says that it is connected mostly, it's not connected to dosage. It's largely, especially for kratom, connected to those 2 alleles, the genetic markers, which increase the likelihood that somebody is going to have an effect due to kratom.
All right, thank you, ma'am. You're done.
Okay, Your Honor. First of all, the counsel made a reference to the fen-phen case and said, I think, that there were clinical studies in the fen-phen, and despite the clinical studies, it led to a big mass tort. Well, I was actually a member of the Plaintiffs Management Committee in the fen-phen case, and I was set to try the first fen-phen case in front of Judge Mahan here before we settled at the last minute. There were no clinical studies on fen-phen. If you remember, fen-phen was a fenfluramine and phentermine combination. And the defendant in the case, American Home Products, made fenfluramine. Phentermine, which is commonly referred to as speed, was made by 50 or so manufacturers. But there were no clinical studies on this combination. It was just 2 drugs put together. And so to suggest that provides some solace for the fact that there were no clinical studies that support the proposition that turmeric causes acute liver injury, I don't really see the connection. Well, let's start with their admissions on turmeric, first of all. They admit there's no in vivo studies. They admit that there's no animal studies. They admit that there's no clinical studies. Nothing except this one paper that I call the Ahmad paper, but let's call it the Dilly paper. I think that's what counsel called it. That's the one that in the title it says growing pains. So in that particular paper, and counsel put it on the screen, it says, quote, 1 in 10,000 to 1 in 100,000, unquote, chance that using turmeric will cause acute liver injury. 10,000 to 1 to 100,000 to 1. And this is their article, Your Honor. This is my article. This is their article. I mean, that is such
Does it say anything? I'm going to ask the same question. Does it say anything regarding turmeric levels?
Okay, on turmeric levels, I just asked Chris to get it. Counsel indicated that there were 6 to 7 grams being ingested a day. That is based upon Dr. Joan, that's Haley's treating physician's medical records. Okay, we have actually produced the remnants of Mr. Haley's turmeric purchases, and you can count how many pills One of them is completely unopened. One of them has 6 or 7 missing. One of them has maybe 10 to 12 missing. I don't know how Dr. DeJean got to this 6 to 7 grams per day. No one really asked him that, drilled down in the deposition. But even if it was 6 to 7 grams a day, if you take a look at the literature, they have found that high doses of turmeric cause no problems. Have you found that one, Chris? Okay. It's in Dr. Singh's study. Maybe we can find it. But that literature, I showed that earlier, Your Honor, referring to the 6 to 7 grams. If we can find it, we'll pop it back up. But so dosage really doesn't matter. And it didn't matter to Dr. Dara because, as I said, Dr. Dara is not going off dosage. She testified that 1 gummy bear is a sufficient dose. She testified that 1 cup of tea with kratom in it is a sufficient dose. So we're really not on a dosing mission here because...
No, I understand that, but I was thinking as a foundation, the literature, they potentially would talk, I mean, for example, if you take too many aspirin, it can cause injury, right?
Well, if they had done any sort of study, any sort of in vivo animal or clinical study, you would think they would focus a little bit on dosing, but since there were no studies, there's no focus on dosing. There's just this really wild speculation, 10,000 to 1, 100,000 to 1. So I think what is really lacking...
The only reason I bring this up, because in a general sense, typically when you see drug-induced injuries, typically there is a focus on dosage. That's
there
why...
is a focus on dosage.
Yeah.
But that's the whole thing about this idiosyncratic theory, okay? It doesn't require dosage. You can take, like I said, I put her testimony up. 1 gummy bear is enough. So it doesn't matter, to her opinion, whether you took 1 gummy bear or 6 or 7 grams a day for 5 years, okay? If it's idiosyncratic, they claim that it could be caused by a super minor exposure. Now, the first problem with this theory, well, I think the first problem is these astronomical odds and the lack of literature, the first 2 problems. But every one of these idiosyncratic theories, and they are theories, jump off with this genetic mutation. Can we have that growing pains paper, Chris? We blow that up so the judge can see it. On that genetic mutation point. Okay, so they found that in 70% of the people had this particular genetic mutation, HLA-B, which I think counsel indicated is determined through a blood test. I don't know whether that's actually true or not, but I'll take her word for it.
And this was this for the turmeric one?
This is the turmeric one, but the same analysis applies to kratom, Your Honor. Theory with kratom is also that there's some kind of genetic mutation. So here they find that 7 out of 10 of these people, and again, we have 10 people over a 16-year time period. 7 out of 10 of these people, 70% have this genetic mutation. So they want to apply this to Haley and Belsky without any evidence whatsoever as to whether or not Mr. Haley has a genetic mutation. Mr. Belsky has a genetic mutation. Can I see the next one, Chris? Yeah, I think we're looking at, no, right there, the table 1. So these are the people, these are the 10 people over 16 years, 5 females, 3 males, go through the race, the age, the latency, but the bottom line here is that they're testing for the genetics. See, it's very top, positive 7 out of 10. I think I said 7 out of 10. So they tested these people, and then 7 of them had a genetic mutation. You would think that a defendant who wants to shoehorn a medical causation theory into such astronomical odds, 10,000 to 1 or 100,000 to 1, you would think they would at least do a genetic mutation test. Okay, so they could come to the court and say, hey, Mr. Belsky or Mr. Haley fall within this category. They didn't do that, Your Honor. They had the right to request a blood sample. They didn't ask for it. And then take a look at this, Your Honor. Under severity, all acute liver injury is not the same.
I understand.
In this case, we had Mrs. Ryerson who died. We had Belsky and Haley both go to the hospital intensive care unit for 4 to 5 days. Some of these people, look at this, mild, 1+. That is the severity level of these liver injury cases. 4 of them were in that category. Moderate, 2+, 3+. Another 3. So, they're calling these acute liver injury cases. In the paper generally refers to them as such, but when you really boil it down, these are not severe liver injury cases. Mild. But in any event, Your Honor, here we have a case, 100,000 to 1 odds, no
How
genetic.
do I read this? Is it saying severe or fatal 0%? Is that it?
Yeah, 4+ or 5+.
Yeah.
So, I give these guys credit out there at the Dilley centers. They're trying to find potential causations, coming up with these theories, and that's what they are. They're theories. Sometimes theories lead somewhere, sometimes they don't. So, out of all the so-called science, this is the only thing they've come up with, Your Honor. And again, this is a case study. Just like the kratom things, they're all case studies. Case studies, by definition, don't meet the requirements of Hallmark. You need in vivo, animal, or clinical. Okay, you just cannot have a case study, whether it's 1 case study or 2 or 3 case studies. And back to the genetic mutation. In this, they say the conclusion is that there's a strong linkage. Can you find that, Chris? Really put in Christopher's paces today. There's a strong linkage, that's their term, between the genetic mutation and the finding of acute liver injury. Again, 7 out of 10, no testing whatsoever in this case. So we're talking an idiosyncratic reaction. Rich, can we have the case, the table? And then they say, oh, Your Honor, this is a growing problem. No, not that table, the bar graph table. This is a growing problem, okay? In the first blue graph, 1 case. In the next one, there's 3 cases. And in the third one, there's 6 cases. Okay, so they say, Judge, this is a growing problem. Well, the authors are kind of cheating here because if you take 2017, 18, 19, 20, 21, and 22, that's a 6-year time period, whereas 13, 14, 15, 16 is a 4-year time period. So they're taking 3 cases over a 4-year time period and comparing them to 6 cases over a lesser time period. It's just not comparable. But, we're talking about such small numbers, such small numbers. And when you look at the ones that they say are this so-called bioavailability concern, they only find half the cases. In 2013 through 16, they find 2, and in the other one, they find, looks like 3. So 5 cases over 16 years, 5 case reports over 16 years. And I already pointed out how the authors specifically say conceivable. This is a theory, okay? This is a theory. And I think Chris finally found the thing that I was looking for. And again, this is from their paper, Your Honor. Safe at 6 grams per day for 4 to 7 weeks. And she referenced Mr. Haley's medical records as saying 6 to 7 grams. And
we don't know what the grammage is because it was a supplement that combined. I get that. I listen.
Right. And then she references Dr. Joan, the treating physician here. I want to defend him a little bit because you got to remember, he wrote down an observation about turmeric back in 2019. That was long before the potential real water risk was known about. He wasn't able to put that on his differential diagnosis. To suggest that a Reno doctor should have forecast that that this alkaline water that Mr. Haley was drinking potentially contained rocket fuel in it, a rocket fuel that causes acute liver injury, and he should have put that on the differential diagnosis and talked about that as opposed to turmeric. I mean, Dr. DeJong was just trying to get to trying to help the patient out, and that's why he referenced turmeric. So to suggest that this is some kind of proof that turmeric can cause acute liver injury, a medical record from a treating physician, that is not science that satisfies Hallmark. So on the bioavailability theory, the theory advanced by this paper, again, no in vivo studies. Okay, they think it's unethical to test it in clinical studies. Well, do an in vivo study. I mean, just do an in vivo study on this bioavailability. They didn't do that. It's unethical to test on people. Do an animal study. Kill some mice and rats. All right, if they can kill them with this substance, they didn't do that. So there's no support whatsoever scientifically for this theory. And now they reference liver tox. Okay, liver tox is not a peer-reviewed journal. So to suggest that liver tox is some sort of scientific literature, I mean, that is very desperate. And then they tell you, Judge, that these gummy bears are so dangerous that they're out there giving acute liver failure to people. There's no warning on this about that. We bought this at Whole Foods last week, these gummy bears. They're selling them in Whole Foods all across the country, Your Honor. And now they're telling the court, oh, this is a big problem. Turning to kratom. Kratom is another thing that they say is idiosyncratic. He could have taken 1 cup, he could have drinking 2 cups a week. Doesn't matter because it's idiosyncratic. They talk about genetic markers. Again, no testing on Mr. Belsky. Didn't ask for a blood draw on him. No proof one way or the other whether or not he falls within this genetic association. And I've yet to see the paper that says 7 out of 10 or something on the genetic marker on this one. So I don't really know where that's coming from, but they're suggesting it's out there. Then they talk about, by my count, 11 different case reports. Dilly, 2015 hepatology report, some 2019 gastro research, Stanford, another one from Cleveland Clinic, one from Northwestern, some from the World Journal, some from 2 other editions of the World Journal, one by UNLV. Well, Your Honor, if you have their opposition, take a look at pages 14 through 15. Not one single one of these 11 so-called scientific reports were cited. Not one. Not one is listed there by name. And again, that's in the opposition 14 to 15. So they come in at the last minute and they throw these up. And these are all case reports. You listen to counsel's description. Not one single in vivo study, not one single animal study, not one single clinical study. These are all case reports. They don't satisfy Hallmark on their face. But what do they say? They all say the same thing, Your Honor. Idiosyncratic. Maybe there's a 100,000 to 1 chance. Maybe there's a 10,000 to 1 chance if you prove that they have the genetic marker. But that is not something that satisfies Hallmark. And think where this potentially is going to take us, Your Honor. This is really going to eviscerate both Hallmark and Williams because now the defense bar can just come in and they can say, we don't need science to prove these alternative causation theories. We could just say they're idiosyncratic. It's a rare thing. It's only 200,000 to 1 people. We don't need any clinical trials or proof of it. We can just say it. That is not what the law requires, Your Honor. The law requires proof. And especially in this case where we have so many clinical trials on turmeric, one by the FDA saying it's safe and effective. We have the most recent clinical trial on kratom that I referenced, which counsel didn't touch with a 10-foot pole because they know what it proves. So you have all the clinical trials proving that both of these drugs are safe and effective, And they come in here and they have nothing. They have absolutely nothing. And then on Mr. Belsky, they try to say, oh, well, there's a reference in the medical records to kratom being a potential cause. Again, Your Honor, a note by an unknown doctor is not science, okay? And I don't fault this person either, because this is Mr. Belsky's hospitalization was 2018. No one knew in 2018 that real water was associated with acute liver injury. I can't fault that doctor for not putting that in the differential diagnosis. And I think the fact that he didn't is not indicative of anything. So for those reasons, Your Honor, we think the motion should be granted. I mean, 100,000 to 1 with absolutely no science, no genetic testing, that is just too far out there to allow an opinion in a court of law. Thank you, Your Honor.
All right. And I've thought about this, and I do have some, and I think it's important to really place a couple of observations on the record. And I've thought about this issue. And the first issue I thought about was the idiosyncratic theory as it pertains to medical causation. And I don't know, I've never read a case where that's been accepted as a viable medical causation theory. And that would go to whether this would be generally accepted in the scientific community under Hallmark. And I do understand that's not always determinative, but I'm going to go back to the case. A couple of issues, too, and I think this is important when it comes to issues regarding the two supplements. And one thing we don't know is this: what is the dosage, and whether the dosage would have been sufficient to cause the potential adverse health outcomes. We don't know that, right? And I think that's really important, because it doesn't matter whatever the supplement might be, or even over-the-counter drugs. If you take too much of anything from a dosage perspective, it can cause adverse, and I forget which one it is. I know you have Tylenol impacts the kidneys. I think Advil might be the liver, or vice versa, but it's the same thing, right? And you look at that. So dosage and length of usage is an important factor too. How often have you been taking it? Very early on, and I picked up on this in this glancing at the articles, I asked a question regarding genetic markers. And it appears to me that was an issue that they were concerned about, was genetic markers. Another issue comes up is, I guess, 1 in 10,000 to 1 in 100,000. If you're able to opine on a medical causation, 1 in 10,000 is sufficient to put it in front of a jury, I could see where that would be problematic. And I don't mind saying that. I'm not going to 1 in 100,000. And there are issues regarding lack of clinical trials and those types of things. I mean, a really good example was the clinical trial issue when it came to the coronavirus vaccine. That was a big deal, right? Before it was made available for the public. We don't have that either. And I mean, in a general sense, I do feel that all these supplements should be regulated, but for whatever reason, they've made a determination not to do so. Ultimately, that potentially impacts the consumer, but that's another story. Let me see here. And it appeared to me when one of the reasons why I brought up the issue as it pertains to genetic markers, that would go to potentially sensitivity to the agent. And I've thought about this, and I've made notes, and I think I think as far as this what we have here, we just don't have sufficient evidence, and I think the doctors are eminently qualified, so it's not a qualification issue. It really goes down to, and it comes down to the assistance requirement as set forth in the Hallmark case. And testable and has been tested? I don't think so, right? Case reports are different than, and you can have a case report published in a accepted journal, but that doesn't stand for the proposition that it's peer reviewed. And here's the thing, when it comes to whether the opinions are based upon particularized facts rather than assumptions, conjecture, or generalizations, it seems to me that in a certain extent, this idiosyncratic theory is based upon generalizations. Because what we don't have is, and I'm circling back, we don't know the dosages, we don't know the length of exposure, we don't know what the genetic markers would be that would demonstrate sensitivity to the two agents and or supplements here. And I understand what's going on, but and I do think this is important to point out, because essentially what this would do, this would eviscerate Hallmark. It would. So I'm going to grant the motions. When you prepare the order, make sure you put my comments in the order.
Your Honor, can we also put in the order, Mr. Kemp raised this, but the majority of those articles were not in the opposition.
Well, were they even relied upon?
And that's my next point. Thank you, Your Honor. We did not see that Dr. Dar relied on the bulk of the articles raised today. The one I asked about specifically, I looked through her reference materials in her initial report and then her rebuttal report while Ms. Anderson was presenting her argument. I did not see the May 11, 2019 article by date in the reference material. And so if I missed it, I apologize, but I think both me and Mr. Pertman were both looking for it. And I didn't see the May 11, 2021, I'm sorry, I said 2021 article in her initial report as a reference item or in her rebuttal as a reference item. If I missed it, I apologize. I just didn't see it.
Okay. If any reports or if any articles weren't relied upon by the experts, those will be rejected. Whatever was relied upon and produced during 16 point will become part of the record. I have no problem with that. But I don't mind saying it. I'm not going to, Hallmark is Hallmark. I'm not going to expand Hallmark to include idiosyncratic theory as the medical causation. And the assistance requirement.
Your Honor, can I say one thing?
Of course, ma'am. You can.
I understand the court's ruling. I did want to just note that we made almost the exact same argument with regard to Dr. Hudson, who said that he had not calculated a dose response as to hydrazine and couldn't say how much hydrazine any of the plaintiffs had or would be required to cause acute liver injury. And that motion was denied. So,
well, I can explain the difference between that, because hydrazine is a known toxin.
So is turmeric.
Well, turmeric sold over the counter.
Well, but under
I mean, really. I mean,
as a supplement that doesn't have to be, that's not regulated.
I can say this: if this container had gummies of hydrazine, Mr. Kemp would not have taken one this morning. That I can tell the court.
I mean, I don't mind saying it, because once again, hydrazine and turmeric, which is an over-the-counter supplement, and with the turmeric, we don't even know what the dosages were. They were part of a supplement package. It's different than hydrazine, right? And as far as turmeric's concerned, we could go get the dosage packages and measure them, right? The hydrazine you couldn't measure, because the hydrazine over time dissipated, right? I mean, there's difference, and and that's why, you know what, I don't mind the Supreme Court looking at this whole case And that's why I was very, very specific as why I ruled the way I ruled on certain issues. And that's fine. They can say, look, Judge, we think we're off track on this one. I'm okay with that. But once again, I think it's important to make sure everybody can make their record. But I do think here, and this is the point. I mean, we're talking about 1 in 10,000 or 1 in 100,000, according to the studies that were produced. You know, and these are OTC. They're not regulated. Should they be? That's another issue. I'm not part of the legislature. If I was, maybe I would look at that differently. So my opinions on that don't really matter. But at the end of the day, it's idiosyncratic theory, right? And if you take a look at the turmeric and the kratom, we had some studies vis-a-vis a case report. You look at the sample size, how many were there? You know, and that's okay. That's my ruling.
Your Honor, I think the next one is plaintiff's number 33. It's 90 on my cheat sheet.
And before we get started, this may be one, I don't know who intends to argue this one against us. I don't know. I figure I'll just ask, because the court's ruling just a second ago affects this motion in part.
Which one is this?
This is 33, points to preclude certain opinions based upon a medical record within Mr. Haley's records. But I think the court's made decision affects this one somewhat. And I don't know who's arguing against, I don't know if it's Anderson or Mr. Neale.
This is 30?
33. Plaintiff's motion limiting number 33. You want to talk about it or figure it out?
No, I'm going to excuse myself and take that phone call.
Okay. Ms. Anderson, you ready, or you want to take a second? Just let me know.
That's fine. We can proceed.
Is it 33?
Yes, Your Honor. And I'll frame the motion, Your Honor, just to give everyone an opportunity, including Ms. Anderson, get her feet under her for this motion, not knowing it was going to be her and Mr. Neale. Your Honor, plaintiff's motion in limiting number 33 was to exclude inadmissible medical causation opinions and hearsay statements regarding turmeric in plaintiff Haley's medical records. Now, the thrust of this motion, Your Honor, and I feel almost embarrassed bringing the motion to you because you're so familiar with Hallmark and you're so familiar with the Williams case. You probably could write the motion, the opposition, and reply in your sleep. And I will go over some of it just to set the stage again, Your Honor. But again, I think the court is very familiar with the Supreme Court pronouncements in these cases, the work you did as a trial judge in Williams. And so a lot of this, I think, will be very, very obvious in terms of why these certain portions of the medical record should not be included. Your Honor, I'm sorry, Chris, can you turn to our motion page 3? And start at lines 19 through 28. So, Your Honor, this part of our brief indicates that Dr. DeJohn in 2019 was not aware of hydrazine in real water. And as a result, he did not include that in his differential diagnosis when treating Mr. Haley. And that's something that Mr. Kemp just spoke about a little while ago. And that's the start of our motion. So what we point out here on this first page towards the bottom, is that Dr. John has not been identified as a treating expert. He's not been identified as an expert by plaintiffs. He's not been identified as an expert by any of the defendants, including UNFW. And Your Honor, you know what Rule 16 requires. And I mentioned this yesterday. Rule 16, point 1A, 2B requires certain things when you designate an expert. CV, trial testimony, deposition testimony, articles prepared or written, as well as a fee schedule. You're familiar with that. And you're also familiar with, if you're going to use a treating physician to provide a causation opinion, you may not have to provide a report, but you still have to provide a CV.
Well, you have to designate them.
Absolutely. No one has designated Dr. DeJohn in this case at all. Number one. So if you're going to seek a causation opinion from a treating physician, you have to designate it. So that's rule number one that's been violated by the defendants if they're trying to get a causation opinion in through a treating physician. That's number one. If you go to page 4, Chris, starting at line 11, and certainly Your Honor recognizes this verbiage. This is from Morsicato. And the paragraph, the quotation, starting at line 11 through 13, indicates that when a defense expert traverses the causation theory offered by the plaintiff and purports to establish an independent causation theory, the testimony must be stated to a reasonable degree of medical probability pursuant to Morsicato. The court's very familiar with that. In this case, the medical records, the portion of medical records that the defendant is trying to utilize and which we believe should be excluded, is a causation indication without it being made to a reasonable degree of medical probability, which is not allowed in the Morsicato or the Williams case. If you go to the bottom of the page, line 27 through 28, again, this is within our quotation, Your Honor, and this is coming from Williams. It says the defense expert's testimony must also be relevant.
But I mean, at the end of the day, unless I'm missing something on the medicine at a very simple baseline, as it relates to, and this, which one is this? Is this the turmeric or the?
This is turmeric, Your Honor.
Yeah, at the very first baseline, I would think first and foremost you would do is you would take some genetic testing to find out what the baseline is, right?
Agreed.
That's what they did. What was it, 7 out of 10, something like that, had the genetic markers?
Exactly.
Okay, you would do that. But secondly, just because something's contained in medical records doesn't mean it comes in. That's exactly what I did in the FGA versus Giglio case. There were medical records saying they had low back pain. And then we dug a little deeper and it was a facet injury and it wasn't a disc injury. It didn't come in.
That's exactly right, Sean. And I said this to Mr. Kemp. He's not, oh, there he is. Before, the defendants had a right to do a Rule 35 IME. They could have taken the test. They could have asked our client to give blood. They could have determined if he had these genetic markers and fit within that non-peer-reviewed article. But they chose not to. So Williams says, and this is what you repeated so many times yesterday when Mr. Hoffman was here, you have to have competent medical research in support of your opinion. You can't just throw unknown pathogens against the wall and hope that it sticks. That doesn't satisfy a hallmark, and it's not allowed under Williams.
See, I'm going to take it to another level. If you're at 1 in 10,000 or 1 in 100,000, I don't know how you can opine to a reasonable degree of medical probability on any issue unless there was, hypothetically, you took genetic markers and then there was a correlation. Look, Judge, every time they take genetic markers, there's a 70% chance it could be turmeric related.
Absolutely.
That's a different issue.
That's exactly right, Joan.
Whereas now we're at 1 in 10,000 or 1 in 100,000, and the law mandates more likely true than not 51%.
They're inviting jury nullification.
Well, actually, I don't see it that way. I look at it from a pure, simple legal analysis under going back to Brown versus Campana, Perez, all those cases flowing up to FGA versus Giglio, Morsicato, Williams, Hallmark, and all the cases. And what's important to point out, and I think this is what's changed in this jurisdiction, 30 years ago, almost anything came in. That's what trial judges would do. They just let anything in and say, okay, the jury's smart enough to decide it. But what's important about Hallmark is essentially this, and I realize we rejected Daubert because our expert testimony rule under Chapter 52 or 50 or whatever it might be is different than the federal rule. And but they did adopt from Daubert the trial court's the gatekeeper.
That's right. That's exactly right, Your Honor.
That's what the law says.
President, you can go to page 6 now. Your Honor, we indicate in our brief here at the top that Dr. Joan, he was never deposed by the defendants. He's not, again, designated. And his opinion, which was not to a reasonable degree of medical probability, was speculative in terms of the turmeric Mr. Haley may have consumed. And so we point that out because going to...
But I mean, here's another thing. I mean, I keep hearing this, but don't we have to have to know what the dosage is?
Your Honor, and that's one of the things that Mr. Kemp brought to light as a follow-up, which is actually memorialized in Dr. Hudson's report. Mr. Kemp provided, through our client, every bottle that he had. Certain bottles weren't even open of the turmeric. The majority of the bottles that we provided were either unopened or only had a few of the turmeric supplements consumed. That's how poor the competent evidence would be in terms of dosage, John, or duration of dosage.
Well, I brought that up, sir.
You did. And so, going to lines 8 through 10, we indicate Nevada law is clear that a treating doctor must be designated as an expert under Rule 6.1. And this goes to the Rodriguez case, or FCH1 LLC case, 130 Nevada 425. Your Honor, and that's why I indicated the 16.1 requirement that was not met here by the defendants. And under Williams, to assist the trier of fact, medical expert testimony regarding causation must be made to a reasonable degree of medical probability. And we cite to that, it's 127, page 529. And I bring that again to the attention of the court because I'm going to show you in a second the medical portion of the medical record that the defendants are trying to get in and demonstrate to you that it's not that diagnosis was not made to a reasonable degree of medical probability. So, Your Honor, if we could, I'm sorry, Chris, if you could go, before we go there, we're going to go to defendant's opposition, Chris. But one other thing I want to point out before we leave this motion, Your Honor. We also point out that the medical records, simply because they may be considered a business record, doesn't mean that everything within the record itself comes in. And you made that point previously, but for some reason the defendant's opposition seems to suggest that anything within a business record comes in. So if there's a...
there has to be a foundation
it's gotta
for anything.
I
mean, that's how we do it in Nevada. There has to be a medical foundation. That's why I excluded the facet injury. The argument was it was the lower back, Judge. It's the lower back. Well, you know what? They're different pain generators.
That's right. So looking at you, by the way, just to address the opposition, I don't want to give all the attention to UNFW. I want to give a little bit to Scott, Mr. Rasmussen. Hanna did an opposition indicating that Dr. Atchison indicated that turmeric is known to cause liver damage and relied on that February 2023 article that we talked about a little while ago. Chris, can you put that article back up for just a second?
Ten cases.
In Your Honor,
I mean, really, 10 cases.
I'm gonna give credit to my daughter, because she went to Stanford, she's in medical school now, she worked at the NIH for 2 years, and so she's been helping me get ready for this case. And I wanted to point out some of the things that we mentioned earlier. If you could, Chris, go up to, go up a little further. You'll see when the, go up, no, up, keep going. Stop right about, keep going. Stop right there. First, I would point out, Your Honor, it says a standardized protocol assesses the causal relationship between the use of a medication or herbal or dietary supplement and liver injury. Causality is graded by expert consensus opinion as either definite, probable, or possible. I'm informed that is the weakest way in terms of approach to determine causation. Clinical studies, like Mr. Kemp was speaking of, is the way, the gold standard in terms of determining causality, not expert consensus opinion. No test on humans, no test on vivos, no animal studies, none of that. Do me a favor, Chris, go up to page.
Wait, go back to
Can we
that.
stop a second?
Wait, I want to read it.
Stop right here. This is a good point. Your Honor, the other point that was not addressed is Anderson talked about black pepper being used in conjunction to make it more, to have more, to promote absorption. But there's no indication of what products he was taking that actually contained pepper. Just that was thrown, it was just thrown out. That's used more often now to help with absorption. But nothing about in terms of Mr. Haley's consumption of turmeric with or without pepper. Tell me when you want to.
No, I'm fine. I just read the whole paragraph.
Go back a little further. Stop. Keep going. Keep going. Slow down right there. It says 5 patients had antinuclear antibody, and had two had low levels of smooth muscle antibody. Your Honor, no one tested, again, a genetic marker, no one tested Mr. Haley for this, or tried to determine if he had any anti-nuclear antibodies or low levels of muscle antibody. Again, trying to draw some relationship between the test results here and what they're trying to do to apply it to Mr. Haley. And again, these antibodies are associated with autoimmune liver injury. Again, there's no determination here in terms of Mr. Haley. All right, go up further, Chris. Further. Go past this, Mr. Kemp talked about that. Slow down. Now we talk. Stop right there. Your Honor, remember I indicated 8 out of 10 people had alcohol use or abuse? Right here. Alcohol use and abuse, 8. Now, there's no indication here that Mr. Haley was abusive towards alcohol. There's been no testimony to determine how much would be use versus abuse, or to compare to these 8 individuals. Additionally, over, Your Honor, here, it speaks about the BMI, which is right above alcohol use. And that was a co-founder as well. Something not addressed in terms of Mr. Haley. Mr. Haley, you may have seen him when Mr. Neale brought him on the screen as a part of his videotape deposition. Very slender person. There are no BMI issues with him. But that was a co-founder or an issue with some of the 10 members of this group. Let's go to discussion. Stop right there. It says here, Your Honor, first sentence under discussion, the experience in Dylan reported here with turmeric-associated liver injury suggests that this phenomenon may be increasing in the United States, at least since 2017. That's a may, as opposed to probable or possible. The other indicators we saw in the beginning of the report. There's nothing definitive about this report. when you relate to those not having these same co-founders, alcohol use or abuse over BMI of 26. It says here, of note, no other drug or herbal and dietary supplement product was implicated in these cases. The author doesn't show any of the data, Your Honor. It's a conclusory remark without any data to support that statement. If we go further, keep going. Right about there. It says here, Your Honor, the increasing popularity of turmeric over the last 5 years, the increase in reported cases.
Well, there's actually a causation issue. Go back. I'm reading this. Just go
Go
back.
down. We'll take a stop, Your Honor.
Go. It says right here, most cases are self-limited with rapid improvement in, go to the next.
Go
Liver test on discontinuing turmeric. Rarely the injury can be severe as a result in death. My point there is this: how can you even make that determination? What's the sample size? 10?
10. The case study of 10, Your Honor. And that's what Mr. Kemp brought up in terms of the difference between transplants, death, hospital stays. Then come back up a little further. Oh, stop right there. So at the bottom of what we were reading here, Your Honor, you got to stop right there. The increasing popularity of turmeric over the last 5 years appears to be to mirror the increase in reported cases collected in respective studies. Your Honor, this case study does not provide any proof from the author supporting this. There's nothing to it. And then finally go to right above the acknowledgement. Go further up. Right there. Stop. Studies of the potential for additive or synergistic hepatotoxicity of turmeric when combined with heparin are needed to better understand the potential mechanism of liver injury. If that's not a punt at the end of a 10-person case study, I don't know what it is, Joan.
Was that even submitted for peer review?
Not to my knowledge, Your Honor.
Yes.
Was it? What happened with that?
I think it was peer reviewed, Your Honor. We don't know what the results are.
I don't know what the results are. I don't know if someone else in the room might.
I have a very short opposition, and then
It is
you can go.
short.
Mine is very short.
I know. I'm still. You hit your Atkinson was one of them, and his reliance on this report.
Right.
So I'm going to hit Atkinson next.
I can, without getting into it. I mean, I can be done here in 2 minutes, and we're done with this motion.
Okay, Your Honor. I don't mind Mr. Rasmussen doing his opposition while I'm doing this part of the motion.
It's real simple. Dr. Joan is a treating physician. I was just going to have him call to the stand and say, "Did you treat this person? What did you see? When he came in, what was he suffering from? Did you see him at this hospital? Did you see him on this date? Did you treat him?" That's it. He's the treating physician. These are questions about whether or not he was in the hospital. What was he suffering from? That's it. What was your diagnosis? What did you give him as medicine? What did you give him as medicine? These are all things that he's a treating physician. What did you do? What'd you find? What you doing there? He's the treating physician. That's all I want him for. I'm not there for him to give me evidence on his expert opinion on causation. I'm there to find out what he did and what he thought at the time. That's just a treating physicians. That's it. What I was worried about with this motion was Mr. Parker and the plaintiff were saying, "Oh, you can't call treating physicians as witnesses in this case." Because if that's where we're going here, I would like to know from the court under Hallmark why treating physicians can't be called as fact witnesses. I can't get that one understood. But other than that, I just know there's the fact witnesses. I was his treating physician. That's it.
So, Your Honor, if Mr. Rasmussen now is taking a position that he's not seeking any form of causation opinion from Dr. DeJean, it varies from what his opposition says.
I mean, I can answer that for you.
Sure.
They wanted to call the treating orthopedic surgeon in the Giglio case for the prior event to testify as to his treatment and care
Okay.
and his facet injury, and I excluded it.
The treating physician.
Absolutely.
So the date that he came in was excluded.
No, I excluded him because it wasn't relevant to the injury.
Okay,
It was
so
a desk injury.
So he has a liver injury. Did you treat him for a liver injury? Which is what we're talking about,
Right?
right?
But I mean, that's different. I mean, if you're going to talk about potential causes,
That's right.
That's a different
That's what you
issue.
said in opposition.
I'm going to ask him, what did you treat? A liver injury. What did you think what the problem was? What's wrong with that question?
you go read FGA.
Okay, if
versus
you think that's a
Gallagher.
bad question, then you'll stop me during trial.
No, but my point is this, and that go read FGA versus Giglio. They wanted to bring in the prior back injury, and she was making a claim for back injury. It was a treating physician. They had undergone a series of facet injections. Facets are different pain generators than a disc injury,
Okay.
right? And what I did was I excluded it. What did the Nevada Supreme Court would do with that issue? They agreed.
Okay.
So my point is this, just because someone's a treating physician doesn't mean they can come in and testify on all issues. It has to be relevant to what the claim is at the time.
Well,
Right.
he's claiming the damages from that hospitalization. So I guess if he can't be brought in,
No, I
we
didn't.
won't use it.
No. I didn't say he couldn't be brought in. I want to make sure the record's clear. And at the end of the day, you're bringing him in for what purpose? Is it to offer up his opinion as to potential cause of why he was there, i.e., turmeric ingestion? That becomes problematic. If you want to bring him in and say, yeah, he suffered a liver injury, and what did you do for him? That might be different.
And Mr. Rasmussen, I will tell you.
Because I don't mind telling everybody. I don't mind saying this. I think I make pretty good records. I've been told by the Supreme Court I do a pretty good job of that because I always explain to them what I'm thinking of.
And Your Honor, I wanted Mr. Rasmussen to be able to say his piece, but
No, I'm going to let him say his piece, but there's a difference there. I'm not because for the record, I want to make sure I'm clear. I'm not saying you can't call him as a treating physician. He's a fact witness. But ultimately, what it comes down to are some of the conclusions. And if the trial court makes a determination regarding prior conclusions of an expert that was a treating physician, right, like I did in FGA versus Giglio, they could have called him and said, but it wasn't relevant. I mean, so I want to make sure I'm clear on that because I'm not painting with a broad brush and say you can't call him as a treating physician. He can come in and testify as to what were his symptoms, what were his complaints, and all those types of things. Because at the time, it's my understanding, based upon the history of this case, at the time, is this Haley or
Haley, this is Haley, Your Honor.
Haley, right? Maybe they didn't know about the hydrazine ingestion, right? I mean,
So
because this is what's important. It's never what's a good for the goose is good for the gander analysis. It comes down to what does the law provide. I mean, that's what it comes down to, and every issue's different. So I'll tell you this, sir, if you want to call him, that's okay. But there'll be limitations on his testimony. That's all I'm saying.
And Your Honor, his opposition, Mr. Rasmussen's opposition, has the word cause riddled through it. And so now he's withdrawing that opposition in terms of causation testimony. Then fine, I can move on to UNFW's opposition.
Yeah, I literally thought that you were saying I cannot have a treating physician testify.
For the record, I'm not saying that.
I know you're not. In reading what was before me, I thought, oh, you're saying a treating physician can't go in and say, did you have a liver injury? Oh, objection! You can't talk about that. That we don't know what caused that, or we do know what caused it. It can only be one thing, and it has to be hydrazine. Okay, all right. If that's what we're saying, that treating physicians have to just follow this one road.
No one.
That's
Please,
the court's ruling. That's fine.
Please don't put words
I'm
in,
not sure,
in
Your
my
Honor.
mouth. I mean, no, that's really important, Mr. Rasmussen. Don't put words in my mouth because I never said that. Right? It's just like, once again, read FGA versus Giglio.
We'll do.
That treating physician I excluded could not come in and testify as it pertained to his facet injury.
Right.
I mean, I didn't. I don't know if the defense called him, but if they had another reason potentially to call him, that might be okay. But they wanted to call him to testify to a pre-existing condition, right? And their position was that it was the facet. No, their position was, oh yeah, Judge, he had a pre-existing back injury. Consequently, it should come in. And what I did during the course of the hearing, I drilled down, okay, what was the source of what was the pain generator? That's the question I asked. What was the pain generator in the prior case? Because the records were there. I knew what it was. I knew it was a facet injury. That's a different issue than a lumbar disc injury involving disc root entrapment at the L45. That's a different issue.
I understand, Your Honor. Thank you very much.
Yeah, I just want to tell you that I'm not painting with a broad brush. It just comes down to whether it was relevant or not.
So I take it from Mr. Rasmussen's remarks, Your Honor, that he now is not opposing our motion as it pertains to causation opinions from Dr. DeJean or within the records of Haley. He's only concerned now with being able to bring Dr. DeJean as a fact witness to offer to, I guess, lay foundation for the medical records related to his care, without the causation opinions which are included within. Correct?
The causation that he sees, and really what it's going to be about is, well, what happened to Mr. Haley too? What happened? What happened to him?
What was his symptoms?
What was the symptoms? What did they alleviate?
Okay, but you're not seeking to have introduced his causation opinions, correct?
I think we're going to be splitting hairs on that because he's going to say he had a liver injury.
We'll finish the motion, Your Honor.
Yeah.
So, Your Honor, to drill down, and I will give credit to UNFW's opposition. Their opposition goes to the actual medical record, and medical record in the opposition is on page 5. So, Chris, can you go to the opposition of UNFW? That right to the bottom. Perfect. Highlight the. So this is the medical record from Dr. DeJean, Your Honor. And it says the likely cause of the patient's hepatitis is toxic levels for his liver of turmeric, which he had been using in abundant quantities, different formulations, drops, preparations, additives, food additives, and pill forms. Patient and his wife brought all the different preparations that he was taking for inflammatory conditions of his joints and amounted to probably 7 grams on a daily basis. Now, this is a couple of things first before we address this in depth. Number one, Ms. Anderson in the prior motion said she was not really concerned about the food additives. She was more concerned about the supplements. Well, I don't know how we get up to 7 grams when you're combining additives and supplements and you're not actually evaluating all of them. The food additives won't have the pepper. So that goes exactly to what the court was saying about dosage and duration of dosage. I thought it was, when the court brought it up, I said, I can't wait to bring this to the court's attention because it goes right back to what the court was saying. Now, Your Honor, you and I know the law on this. I think everyone knows the law on this. But I'll point it out. If a doctor could not come in here and testify for himself under Hallmark and Williams to a reasonable degree of medical probability, then you cannot bring a defense expert in here to serve as a conduit to try to get that opinion in. And that's what the defendants were trying to do. They're trying to get this record in to suggest to this jury that this doctor is offering this opinion to a reasonable degree of medical probability and has actually done a differential diagnosis to come up with this conclusion. And that's simply not the case. This is a hearsay document, and there's an improper opinion not qualified under Hallmark to be brought before this jury. I'd also want you to direct the court's attention to page 10 of this opposition. Because this is an admission on the part of UNFW which prevents them from using Dr. John in the way they'd like to. Go to the bottom, starting at line 28. It says here, stop right, there you go. Plaintiffs are correct that UNFW did not designate Mr. Haley's treating physician as expert witness, but that does not make their records inadmissible. So they admit that under Rule 16, they've not done it correctly, though. If they wanted to get a causation opinion out of Dr. DeJohn, they had to comply with Rule 16.12b, which they did not do. Now they try to get that opinion from Dr. DeJohn in before the court and before the jury without having it to a reasonable degree of medical probability, which is prohibited under Williams. Go to the reply brief, page 3. Page 3, lines 2 through 6. And this comes straight out of Williams, John. That's not page 3, Chris. It's not page 3 on my document. John replies. Your Honor, while Chris is looking up, it says, thus any expert opinion on the alternative turmeric causation theory is subject to the reasonable degree of medical probability standard pronounced in Williams versus the 8th Judicial District Court, 127 Nevada, 518-11. The defendant seeks to traverse plaintiff's case by proposing an independent alternative causation theory. The expert testimony is subject to the reasonable degree of medical probability standard. Now, Your Honor just went through for about 2.5 hours the prior motion, which was granted by the court, preventing Dr. Dara from advancing this theory. And here, UNFW would have Dr. DeJohn do the exact same thing through using his medical record. Again, it does not fit the standard. And the case that goes to the point that you cannot use an expert to get in a hearsay document for purposes of offering an opinion not to a reasonable degree of medical probability, Your Honor, is on, let's go to page 7 of our reply brief, lines 11 through 15. It says here, Your Honor, an expert witness may not be used as a mere conduit to introduce the statements of a non-testifying individual. This is Colon versus State, 127 Nevada, 11/27, 2011. Citing McCatherine versus Toyota Motor Corp, which is we have a P30 site, Oregon, 2001. And Your Honor, I know you know this. I want to make the record real clear why we're taking the position we're taking. If you could, Chris, please put up the deposition of Dr. Atkinson. I want you to go to page 76. And I raised Dr. Atkinson's deposition, Your Honor, because Mr. Rasmussen raised this issue in his opposition. So line 6 through, we'll go to page 77, line 14. Let's start here. Question. It says, okay, well, with regard to that standard, reasonable degree of medical certainty, you can't say with regards to Haley that it was turmeric. I think you talked about some other substance with him or some unknown cause. You can't say any of those things about the cause, right? What's Dr. Atkinson say? That is correct. That's the end of the day, Your Honor. Once he says he can't do it to a reasonable degree of medical probability, under Hallmark and Williams, he's done. And there's no equivocation. I cannot say with a reasonable degree of medical certainty that turmeric was responsible for Mr. Haley's acute failure. Yes. Now, I want you to now go to Dr. Dara. And this is a longer site, Your Honor, so I apologize. Go to page 158. And starting at line 21, Chris. It says, I have seen evidence that Mr. Haley was taking other supplements along with gummy bears every day. And I actually have a note in the chart from his wife that called the doctor's office and told him he was taking a lot of turmeric. Now, Your Honor, it goes a long way, and I don't want to read all the.
I'm letting everybody make the record, Mr.
Just go ahead and make it.
Yeah, I'm letting everybody make the record.
All right, I apologize. So, the question goes on, and what is the basis of your information that Mr. Haley was a wife? Answer, it says wife in the note, I think it's Jessica, the partner. It says for some reason she introduced herself as a wife. I think in the deposition he called her partner, kind of, he said, you can call her my wife. So I think they're very close, they've been together for a very long time. But what it sounds like in the deposition, that she's the one who called and told the nurse that he was taking a lot of dietary supplements, and the nurse documented it in the medical records. Well, Chris. There's also notes from the family practice doctor. Your Honor, this is the 7 grams he talks about here. It says, and there's notes from Dr. DeJohn that says he brought in his supplements, and contemporaneously Dr. DeJohn documented he took 7 grams. We cannot, this is where she gets back in. We cannot dispute how much he took. But basically the jury has decided do they believe this physician who back in 2019 documented at the time how much he took, or how much Mr. Haley called in 2023 he took in 2019. Here's where the speculation just grows on. Keep going, Chris. So regardless to me, honestly, how much he took doesn't make a huge difference because these are idiosyncratic reactions. So getting back to what Mr. Kemp said earlier, and what the court brought to everyone's attention, she has thrown out dosage completely and duration, and it's come down to only idiosyncratic reactions. We know he took some turmeric in the form of supplements, and it was at least 4 different brands you sent us in the pictures that he was taking. So he was at least taking 4 different kinds of turmeric. I think that's enough to cause an idiosyncratic drug reaction. It doesn't have to be exactly 7 brands. Whether you believe Dr. John or not, I don't know why Dr. John would lie back in 2019, what he would gain from incorrectly documenting this. But if you don't believe that, it's fine. He can still get liver injury from a smaller amount. Again, playing on the court's concern that no dosage has been tied to the liver injury. Continue, Chris. So you said that the partner was the source of the information. The partner made the phone call. I don't hear him. Do you hear him? There's an issue with, I guess, coming through. Mr. Kemp says, you said the partner made a phone call to Dr. John and reported 7 grams of daily usage. The response, no. The partner made a phone call, the nurse documented a phone call from the partner saying that he was using a lot of turmeric supplements. It's in the medical record, I can get it for you. Keep going, Chris. So the question is, that's the source of the 7 grams, right? No. The source of the 7 grams is Dr. John's note that I saw you had put as a supplement here, so Dr. John's notes. He's kind of gave us a table, so let me find that. That's the source of the 7 grams. Now, this is where she reads in the medical record. The likely cause of the patient's hepatitis is toxic levels of his liver of turmeric, which he had been using in abundant quantities in different formulations, drops, preparations, food additives, and pill form. I don't know what he means by that. Again, their expert not being able to quantify what Dr. John meant by his description of the quantity of different types of turmeric. Capsule, I don't know. Baby gummy. The patient and his wife, I guess everybody assumed that she was his wife, I guess partner, we should say, brought and all the different preparations he was taking. So he saw all the different bottles for inflammatory condition of his joints and his amount of probably 7 grams of cases. So it is. Now you can argue with that, but that is documented on the October 10th, 2019. That was a record that Ms. Anderson read earlier, Your Honor. So it can be incorrect. It's about his recollection versus what the doctor documented contemporaneously, and the jury can make that decision. I don't care either way. We knew he took some turmeric. That's all I'm saying. It's an idiosyncratic reaction, and he took some turmeric. Mr. Kemp tried to reel back in. Back to my question. Which led to this little exchange? Have you seen any objective evidence that Mr. Haley was taking 35 of these gummy bears every day? Objective evidence regarding gummy bear in particular, no. He was taking out of preparations, multiple things, as I just read. Okay, have you looked at the pictures of the turmeric supplement bottles? I have. So Mr. Kemp brought the bottles in, like I was describing earlier, so that all of the experts would be aware of how little Mr. Haley took. She said, right, but there could have been bottles that he finished. Speculation. Next question. So there's theoretical bottles out there that you have no evidence of that you think he was taking. Is that right? He says, I have evidence because there's a contemporaneous medical record from the doctor who saw the supplements and calculated. Listen, the jury is going to understand what a medical record is. Why would a doctor calculate something, making something up, and put it in the medical record back in 2019? Why would Mr. Haley's partner call the nurse and say he was taking large amounts? That's the quote, large amounts of supplements containing turmeric. We're just about done, Your Honor. We finished at 9:25. It says here, why would she do that when he was in the hospital? Why would they tell the primary care physician, Dr. Silverman, they were taking large amounts of supplements? So there's nothing theoretical about this. It's actually the medical records. You and I can go for whatever. It's going to be up to the jury to decide do they believe the medical record or the recollection of the patient. So this is where we get to the bottom line. Literally and figuratively. It says here, that's the bottom line. Again, it doesn't matter how much. It's an idiosyncratic reaction, so you're just, it says, that's what I was going to say. It doesn't. You come to the same opinion. If he took one gummy bear and told the doctor that, you'd have the same opinion here today. And this is her response, the culmination of 3 pages of deposition testimony. I think so. I think it's an idiosyncratic reaction, so the total dose doesn't matter. But he was taking more than one for sure, because he was taking it for a while. There's at least 30 tablets missing from one of these, something like that, so he was taking it for a while. That's it. She says it doesn't matter dosage at all. So when you consider that, in her opinion, dosage doesn't matter, when you consider
Duration doesn't matter.
her opinion is going to be whatever her opinion is in support of UNFW, because she's done no testing. They didn't do a Rule 35 request. There's no correlation between the one study that she's using and Mr. Haley. They're trying to get an opinion from a doctor that's not in conformance with Hallmark. There is no way, Your Honor, under Hallmark or Williams, that portion of the medical records come in, and there's no way under our case law that another retained expert would be able to get that opinion. And given the court's prior ruling, Your Honor, this motion, in our opinion, should be granted.
All right, I understand. I just have one comment. I would think at a very minimal baseline, there would have to be some sort of genetic testing as the foundation for this idiosyncratic reaction, because in the studies as it pertained to turmeric, they did that.
That's right. That's right, Your Honor.
Okay, let's do the opposition.
Your Honor is now the time to take a break.
Yeah, probably. Let's take 15.
All right.